Honourable John Boscawen.
Thank you, Mr Speaker. It's a privilege to stand up and take a call on the 15 bills that come out of the Criminal Procedure and Modernisation Bill, Mr Speaker. And particularly a privilege for me, Mr Speaker, because this week for me, I suspect, will be my last week in this debating chamber as a Member of Parliament. And, Mr Speaker, there are probably few examples of being so proud of a piece of legislation as this one. So the ACT Party plays a vital role in this House. Above all else, Mr Speaker, we have contributed to a stable government over the last 3 years. However, we've also supported the National Party in all of their major legislative initiatives, their legislative program. But where necessary, Mr Speaker, we have held the government, we have held the National Party to account. And so there can be no better examples of that, Mr Speaker, than both this bill, sir, the Criminal Procedures and Modernisation Bill, and the Video Surveillance Bill, sir, both bills which have been particularly before members over the last 2 or 3 weeks, and of course the Surveillance Bill coming up in the House later this week under urgency. And sir, the Criminal Procedure Bill comes before the House with major changes, Mr Speaker, and those changes would not have occurred without ACT's involvement. In fact, Mr Speaker, it is the actions of the 5 ACT MPs in unison, sir, who drove those changes. I want to come back later, Mr Speaker, to the comments to Mr Chauvel, which I want to respond to, but the public of New Zealand should be in no doubt whatsoever. It is the actions of 5 ACT MPs who universally stood against this bill, Mr Speaker, in the form that it came back from the Select Committee. And without doubt, Mr Speaker, had we agreed to those changes, this bill would have passed in the format agreed by the Select Committee, agreed by the National Party majority, and, sir, a format substantially different in substance than the bill before this House today, sir. And without doubt, the most significant of those changes, Mr Speaker, is the change truly withholding the right to silence, sir. That's right, upholding the right to silence. And it's interesting to hear the comments or the interjections of Mr Simon Bridges, and I'll come back to his response or his comments, Mr Speaker, in earlier readings in this bill, sir. And without doubt, this bill, as originally reported back, sir, would have severely curtailed that right to silence. And so that is a breach of a major constitutional provision, sir. And, sir, if Mr Bridges doesn't actually accept that, it sadly shows that he didn't actually understand what was in the bill when it was originally reported back. Sir, when the bill was reported back, sir, it would have required a defendant, a person charged with a criminal offence, to identify which part of the Crown's case against them they didn't agree with them. The defendant would have been required to tell the police, tell the Crown Counsel what parts of the evidence against them they didn't agree with them, sir. And, sir, if the defendant had failed to do that, sir, the court would have been able to draw an adverse inference. A jury could have found a person guilty where they might otherwise not have found a person guilty. A judge, sir, could have found a person guilty where he or she may not otherwise have found that person guilty, sir. And the fact is, sir, that by requiring a defendant to identify the so-called issues in dispute would have allowed the prosecution to fashion the evidence, to train the witnesses, to say to the witnesses, this is where the cross-examined questions will come from, to actually train the witnesses as to how better to answer the questions put to them by counsel for the defendant, Mr Speaker. And, sir, as the Green Party Speaker has just acknowledged, sir, we need to be very careful to protect the weak, because we need to acknowledge, sir, the substantial difference between the resources and the power of someone charged with a criminal offence, sir, and the resources and the power of the state to bring charges against them. And, sir, this party, the ACT Party, was asked to support the bill as originally reported back that would have required a defendant to identify to the police the issues with the police case that they disagreed with, that would then have allowed the police to train the witnesses as to how better to fashion their evidence, sir. And so we insisted that that provision be taken out, It comes back into the House this afternoon with that provision taken out. And so the right of an ordinary person to stand up, sir, to defend themselves, to be proved guilty beyond all reasonable doubt, sir, that major constitutional principle remains, Mr. Speaker. Sir, the Minister identified some additional changes that the ACT Party was also instrumental in achieving, and I do acknowledge Mr. Chevelle, and I do acknowledge his minority member's report. Sir, it is a fact that when the bill originally came back, it would have enabled the Crown to deny a person a jury trial if that person had been charged with a criminal offence that carried a sentence in prison of 3 years or less. And so the ACT Party insisted that that be dropped back from 3 years to 2 years, sir. And I want to, in this particular instance, Mr. Speaker, refer to the submission of Family First. One of the things I've been able to do, Mr. Speaker, in my 3 years in Parliament is to present a private member's bill, sir, that would have tried to implement the compromise on the so-called smacking legislation that this House looked at in the prior term, sir. The Family First and myself have been absolutely unrelenting in our determination, sir, that that legislation be repealed or certainly amended. And so the Family First state in their submission that certain charges, for example, charges where a man assaulting a female or a parent assaulting a child, a charge like that, sir, would have carried or carries, sir, a maximum prison sentence of 2 years in prison. And, sir, under the bill as originally reported back by the Select Committee, a parent charged with smacking their child, Mr. Speaker, charged with assault, would not have been entitled to elect a jury trial. And one of the benefits, sir, of the changes that we have made is to allow a parent charged with smacking their child, Mr. Speaker, to actually be trialled by their peers. Mr. Speaker. And I think that this Parliament and the people of New Zealand owe a huge credit to organisations such as Family First and the various other lobby groups, Mr. Speaker, that stand up for the rights of New Zealand, take an interest in civil society. Sir, those different groups represent all sides of the political spectrum, from the left to the right. While individual members of this House may not particularly agree with the submission of one particular organisation or another, we should actually acknowledge the work that those organisations do, Mr. Speaker, and Family First is an example of one of those organisations, sir. So this bill has also received submissions from a number of other organisations, and particularly, as you would expect, organisations associated with the legal fraternity. We've had a submission from multiple submissions and additional submissions, Mr. Speaker, from the New Zealand Law Society, from the Criminal Bar Association, certainly the Wellington Criminal Bar Association, various barristers, no less a person so than the Chief Justice made a submission on this bill, Mr. Speaker. But what I would like to do, Mr. Speaker, is acknowledge 3 barristers who I think have done more than anyone else here in this country to bring to politicians' attention the issues associated with this bill. And I'd like to again acknowledge Patrick Winkler and his assistant Samira Tagavi and Roderick Mulgan. And I would like to record into Hansard Mr. Chevelle's agreeing with me, because, sir, we have been lobbied by those people. We've been lobbied to do the right thing, and that's been at big personal cost in terms of money and of time. Sir, Mr. Chevelle commented on the fact that the ACT Party was late coming to the argument, that the Minister didn't have the numbers, or that the Minister lost the numbers. Well, the blunt reality, Mr. Speaker, is the Minister never had the numbers. The Minister never had the numbers. The ACT Party supported this legislation to first select committee, so first reading, as we do most legislations, because we wanted the people of New Zealand to have the right to submit on this legislation. We don't actually have a representative on the Justice and Electoral Select Committee, Mr. Speaker. And so when we saw the implication of this bill to a man, sir, to a person, Mr. Speaker, our ACT caucus was absolutely united against us and against this bill. And we're very pleased that this bill comes back before the House with major changes, not just to the jury provision, the issues associated with having to identify issues in dispute, but with changes to the imposing of court orders, the changes to Section 376, which would have increased the threshold for getting a new trial, Mr Speaker, from previously a carriage of justice to a miscarriage of justice. Mr Speaker, the ACT Party is proud of the bill in its form, and nothing, sir, highlights the vital role we play, sir, in this particular piece of legislation. Thank you.
Rahui Katini.
Thank you.